Welcome everyone to the fifth annual Parent Network Conference. We are super excited to have everyone here today. Right now, we are going to have the session, What Happens Now? Understanding Mental Health Care in Idaho's Juvenile Justice System. We are very excited for this presentation, but before we get started, we wanted to do just a couple housekeeping items. First of all, if you have questions during the session, Zoom does have a Q&A feature. Put your questions there. It makes this a little bit easier for us to answer and keep track of them than if you use the chat. We have a poll that we will give you. It is anonymous, but if you help us with that, then we kind of know who we're talking to. It makes our comments a little more targeted. After the session, you are going to see a survey. If you could fill that out, it helps us. It just helps us make our sessions better and our workshops better as we continue. If you are an Idaho parent, the Idaho Parent Network has just come out with their new survey. And so you can find that on idahoparentnetwork.org. It will also be in a link that is emailed to you tomorrow. In the coming days, we are going to be posting the recording of this along with the slides and some resources. So make sure you check back at the Parent Network website and you'll have those things at your disposal. So if you, as we get started, I want to introduce you to our guests. We have Judge Kathleen McGregor Irby with us, and she is from Ada County Court, Juvenile Court. We have Darren Burrell. He is the Chief Probation Officer and Department Administrator from Fremont and Clark County Juvenile Probation. We have Mindy Jensen, who is a clinician at 5 Counties Detention, Youth and Rehabilitation. You might know that as 5C. And James Phillips is a juvenile placement manager from the Idaho Department of Juvenile Corrections. We are very excited to have everybody with us. And with that, we'll go ahead and we're going to talk about these things today. So this is what we're going to do. We're going to understand the relationship between the local, the county, and state parts of the juvenile system. We are going to explore the roles of county probation, county detention, the juvenile courts system, and Idjc in mental health care, and also identify ways for families to engage in the juvenile justice system. So to get started, this is a bifurcated system, and that really means it's split between state and county. Our court systems, the judges work for the state, and the juvenile correction centers are part of a state system. On the county level, we have a lot of people. We have prosecution and public defenders, diversion, probation, and detention facilities. And depending on where you live, some of you are served by a county sheriff. Now, on the local side, kind of below that line, some areas have local law enforcement, but they do feed into county detention and probation systems. So as we get going, we're going to start by talking a little bit about county detention facilities. And in the Idjc, which stands for the Idaho Department of Juvenile Corrections, they have a new handbook for families. And this is a quote that they find in that handbook. Many positive things happen in a detention facility. Youth are cared for and they're safe. They begin to learn skills and help them make positive changes as soon as they arrive. And staff members work hard to help them transition home successfully. So now we're going to talk to Mindy and talk a little bit about county detention facilities.
Thank you. So the first question is, what role does the county detention facilities play in helping kids get or maintain their mental health treatment? And my role as a clinician in the detention center is to provide clinical services to those kids. That includes clinical screenings, crisis support, clinical interventions, case management, clinical consultation, transitional services, and staff training. So we're helping make sure that the kids get connected and get the mental health treatment that they need while they're here in the facilities. We typically do crisis work, but we're here helping with any needs that may arise. Is there any mental health assessments or treatment while in the county detention facility? Yes. So we do 3 standard assessments that we do. One is the MACI, the Alaska, and the ACEs assessment. We do all 3 of those while they're here. We also are always looking out for any crisis. So if they're having suicidal thoughts or self-harming, tendencies, we're always looking out for those to make sure that your kids are safe and that they are cared for while they're here, and that those needs are addressed. If mental health treatment is provided while in county detention facility, is that information part of the official court record? So as far as the assessments that I do and the notes that I take, you know, we go by the same privacy laws that we would in a private practice here. So we're not giving people details unless a report needs to be made or things like that. But we do give the probation officers and the parents a brief overview of the assessments that are completed here in the detention facility. And so it's up to the probation officer whether or not they show that to the judge. Sometimes we're asked to give provisional diagnoses and recommendations. So we can recommend that a child be connected with individual counseling or family counseling or CBRS services. We can recommend that they get a more extensive mental health assessment. So we can make all of those recommendations, and that may be something that comes up in the official court record, but that doesn't mean that I'm giving them the notes of a session that I have done with a child. Common questions from families. Will my child get their medications? Absolutely. As your child comes in and we do the intake process, if you could be proactive and bring their medications, that would be awesome. We always verify medications with pharmacies to make sure that these medications are prescribed for the children and they do get their medications while they're here. If they need to see a mental health provider, we are in favor of them keeping that continuity with their regular mental health provider. If they need something with a crisis, I'm happy to step in. We're on call and we come in if they have a crisis situation. If they need to see a mental health provider, we can absolutely help facilitate that. We have Zoom capability, or when visitors are allowed back in the facilities, their mental health providers can visit them here as long as the probation officer approves that. Am I responsible for paying for treatment while in county detention facility? Your children would still be on your insurances. And so yes, you would still be responsible for paying any treatments, like if they saw their mental health provider or anything like that. But as a detention facility, like I don't charge for my crisis services or those assessments while they're here. So tips for parents would be make the facility aware of any medications that your child may need while in the detention facility and any special needs that they have, and respond to any requests that we may have. That helps us to make sure that we're meeting your child's needs when they need it. If you give us the information that you have, it helps us be more efficient.
So Mindy, a lot of the families that come and talk to us, they're afraid to ask questions. They're afraid that anything they say, I mean, they've watched enough television that anything they say can and will be used against them. And so they're really afraid to talk to the people at the detention facility for fear of saying something or doing something that's going to make things worse. And I think that fear maybe keeps them from interacting a little bit. How do they ask questions the right way or get the information they need? I mean, who is their contact? Who should they be talking to?
They can always call the main line here at the detention facility. The control booth will answer the phone, but they are more than welcome to ask for the detention clinician. I'm here to help collaborate and advocate for both you and your child to make sure that your voice is heard and that all of your questions are answered. So they can always call in and ask the detention facilities to speak to the detention clinician. And then that message will get to me.
That's wonderful. And all of the detention centers or facilities have a clinician on staff, correct?
That's correct.
Okay, that is great to know. Thank you.
Yeah.
So now we're going to move into juvenile court, and the presentation is kind of set up in the order you see people traditionally, though some people go out of order. But we have a lot of questions that come from families really around what happens when we go into the courtroom. So once again, out of the parent handbook, this is some information that they felt that should be shared. Parent participation is vital and families have an important voice in the juvenile justice system. And juvenile court is about skill development and not punishment. I know that that was something that when I heard it the first time, it made me stop and think, you know, gosh, I had never thought of it that way. So go ahead. Take yourself off mute though.
There we go. Thank you, Laura. Yeah, the juvenile court is really designed to develop competency in areas where we could help kids gain, necessary tools to help them make good decisions and improve their issues regarding various things, including mental health. The first question that I had on the sheet given to me was, what role does the court have in the juvenile mental health in juvenile mental health treatment? Well, I think initially, when we see juveniles that come before the court, we have an obligation to inquire if perhaps the child's involvement at the juvenile court level is, or the delinquent behavior that we may be seeing is associated with some mental health issue. And that information could come to us in a variety of ways. The parents can voice that. I can sometimes see it obviated in their appearance in the courtroom. I can hear that information from clinicians in the detention center, sometimes might voice concern, or even attorneys for the juvenile might express some issue that they might be seeing that could warrant an intervention. So yeah, our job is to address those issues, mental health issues, if they are identified. Does the court have access to any mental health treatments that are not available through the Division of Children's Mental Health or Medicaid? I would say no. I would say that we have the same ability to access services in the community or through the Department of Health and Welfare. We don't have any special, necessarily special interventions that we offer. Maybe counties differ in that service statewide. I'm not sure, but we work through the YES program, which is through Children's Mental Health. And the families can access that actually without having to enter the juvenile court system. So I would say no, we don't have any unique or different programs that parents can't otherwise avail themselves of in the community. Some common questions that we get from families who enter the court system are, and these are kind of legal questions in some regards, so I don't want to be too simplistic, but I think I have to be in some ways to explain this. What is competency? Competency is actually statutorily defined, and competency, I would have to say that generally most kids are competent to proceed in the juvenile court. But generally speaking, the definition of legal competency is that is the child sufficiently able to consult with their lawyer with a reasonable degree of understanding? Is that understanding, can the child understand the proceedings against him? And then the capacity to assist the lawyer in preparing a defense. So those are, legally speaking, kind of the criteria that we have to look at in assessing competency. So if we're questioning those things, then it would be appropriate to initiate an evaluation process to address whether or not the child is in fact legally competent. Any party can ask to have the juvenile have a competency evaluation. That can be, and then that could include the court. Again, I could observe something that maybe makes me question their competency, or a parent could ask to have that issue addressed, or the attorney. It often comes from the attorney for the juvenile who will initiate that competency evaluation process. And once a child's competency is brought into question, then the proceedings are suspended while that evaluation process takes place. And that has to be within 30 days that we would have that take place. And then when we get the answer to that question, then we can move forward. Sometimes kids are deemed competent and can move forward then right away in their matters before the court. If the competency evaluator is concerned about their abilities to understand the proceeding or some of these other criteria, they may say, you know, they're not competent right now, but they may be if we work with them and restore them or educate them about this process and get them to a place where they could understand it better. And so in that event, then proceedings can be suspended up to 90 days while they work to educate that child about going through the juvenile court process. And then sometimes there are children who are just deemed to not understand because of their disability or their mental health issues that, and they won't ever be able to understand. That's rare, I would say, but it does happen. And then the next question is the 2511A process. I would have to just point out, first of all, that the 2511A is different than the 20-519A competency issue. So competency is separate than an inquiry regarding a child's mental health. And the 20-511A process is really something that is initiated when we see a child who's suffering from a severe or substantial increase in emotional disturbance that's impairing their ability to perhaps follow directions or orders of a court. So this is a child we probably have been dealing with on some level for a little bit of time, and that they have already been trying services in the community to address perhaps their mental health issues, and maybe those services, because part of the finding that the court has to make is that their mental health issues have not been adequately addressed with supportive services or corrective measures previously provided to the child. So the 2511A is more of a deep dive into a child's mental health, and more of a, we've tried everything in the community. Is there other things that maybe we could look to that we haven't, that we're not aware of? So it's kind of a bringing everybody to the table and collaborating around what other options might there be out there. So those competency and mental health assessments are different. The next question is, can a judge ask about a past mental health assessment or diagnosis, or tell my child to get one? Yes, to all of those. I can ask about any assessments or diagnoses. I can ask that they be released to our clinicians or our, and obviously this is, it kind of depends too on what stage of the proceeding you are at jurisdictionally. But generally, yes, we can ask for these things and provide them to our probation officers and clinicians so that they can have a better understanding of what has been tried or what hasn't been tried, and just to educate and help guide those people who are involved with the child. How do we know if a child may be going to a juvenile correction center? Who can be part of the Rule 19 screening? So the Juvenile Correction Center, I don't know if that means detention center or the Department of Juvenile Corrections. I'm assuming because you've mentioned Rule 19, it means Department of Juvenile Corrections. So again, this issue is probably an issue that comes up later in the child's involvement with the juvenile court. So you won't see a child typically going to the Department of Juvenile Corrections on their first offense. They will have had a substantial contact with the juvenile court in their area, most likely, and substantial time spent with interventions in the community to help address competency developments in an effort to not send them to DJC or to the Department of Juvenile Corrections. We really want only the kids that are really high risk or dangerous kids at DJC. And so usually in my experience, that's Rule 19 screenings occur, well into a child's involvement with the juvenile court. So I don't think parents should fear that their kids are going to go to DJC on their first experience with juvenile court. I don't know that that is necessarily on the table, but there are cases that if it's extremely violent or sexual in nature, maybe sometimes it's warranted in those extreme types of situations. The Rule 19 screening team, if you ever get to that point where your child is possibly going to be committed to the Department of Juvenile Corrections, we want everyone we can get to the table at that meeting. And so the statute provides that obviously parents, custodians, and the juvenile are to be part of that screening team. The juvenile's attorney, the prosecutor perhaps, probation officers, DJC representatives, local school officials who've had, or educators who have been involved with the child over time, or really any other person who may have information that the screening team thinks would be helpful, such as counselors the child has worked with regarding mental health or substance abuse issues, or doctors, people that could help identify whether or not essentially that child is someone that should be committed to the Department of Juvenile Corrections. Common questions for families. Does the mental health of the other members of the family impact my child's case? And is that part of a safety assessment? So yes, the court is always mindful and wants to be aware of any issues that impact a child's ability to participate in the juvenile court proceedings or comply with his probation. So if there's ever issues that people are aware of that could impact a child's safety, it's important that they bring that before the court. The court does have jurisdiction over parents or guardians regarding a child, and so could employ measures to help the family if there are issues, and perhaps even remove a child at an extreme level if their concerns are significant enough that the child has been abused, abandoned, or neglected. But yes, we can inquire of safety for a child and employ safety plans to help support the family. And so on a general level, I guess that's the best way I can answer that. I would support the comments that were put out on this tips for positive collaboration. Maintain communication with the defense attorney. That's called the public defender. Yes, it's very important that the juvenile and the parents maintain a relationship that allows the defense attorney access to the child to meet with them to prepare their defense and help them through this process. Definitely participate in whatever screening teams or assessments and examinations that the court has initiated, because parents and family participation is so important in helping to educate the court and the treatment providers, clinicians, probation officers around issues the family or the child might be having. And then definitely engage in that treatment. We can't help your child unless, or help kids unless we have the engagement of the people in their homes, most importantly, their parents or custodians, and getting them the treatment they are being ordered by the court, or parents participating themselves in that. So they're a crucial part of this process.
So out of curiosity, when we talk to families who are coming into a court, they're scared. They are unsure of the next steps. And just like I mentioned with the detention facility, they're worried that anything they say is going to make it worse. So what advice do you have for parents who are coming in the first time? I mean, obviously, there's the etiquette of court that, don't show up in your bathing suit and or your Halloween costume. That may be my favorite piece of advice I was given by an attorney.
Yeah.
But
yeah, those are good questions. Court looks a little different now. We are doing all of our court remotely or virtually like this experience right now. So at some level, I think that that's helped alleviate some anxiety that parents might be having because they're not having to physically be here in the courtroom. I imagine that we will get back to some degree of what we did before. Although I think this whole Corona experience has opened up some new ways for us to have parents participate in court, because oftentimes this process can be disruptive to their jobs and their responsibilities outside of their obligations to their children. And so I think this kind of new platform that we have could be really helpful and useful for families moving forward. So I'm hoping that we can use some form of this continued kind of video court moving forward. But that being said, I try and approach my families when they come into court or participate in these proceedings by really explaining what are we doing that day, and helping them understand what's happening that day, not only to make sure the juvenile understands, but also the family does. And there's never any question that is too ridiculous to ask. And so my advice to parents are, I'm here to help, you and your child through this process. So please ask any question you think is something you want help understanding. And if I can, I will help them. If I can't, because it maybe involves giving them legal advice, which I can't do, then I will, help them find out where they could get that question answered. So yeah, don't feel like you can't ask any questions. And it can be an intimidating process. If it isn't intimidating on some level, then maybe you've been involved for too long, or maybe you've been around for too long. Maybe, I don't know.
I did find walking in the doors to be just overwhelming,
Yeah.
But then once I was there, I found that everyone was incredibly nice, which was good, because if they hadn't been, I might have, started crying.
Yeah, I mean, I think your comments at the outset of this and the slide that you showed, I think it was from Idjc, is juvenile court is different than adult court. We are designed to really provide these kids and families with interventions to increase competency and skill sets, and help in areas to have them avoid juvenile court. So we're really wanting, all of the stakeholders involved in this process on some level are really wanting to assist the family. So yeah, don't be afraid to ask questions.
I appreciate it. So now we're going to move on to what happens in county probation and diversion. And we'll have Darren talk to us a little bit about this. But one of the things that I think it's important to note is that diversion is frequently, if not always, run by county, and probation and diversion are in fact different. So this is once again out of the Idjc handbook. Probation officers see themselves as a guide for youth and families throughout the juvenile justice process. They are available to assist families by providing services and monitoring compliance with court orders. So go ahead, Darren, let us know what we need to know.
Yeah, hey, thank you for inviting me to be part of this discussion. Thank you to Laura and everyone else that have actively put this together, and it's an honor for me to be on this panel with some really stellar individuals. So it's my hope that we can maybe illuminate the path you're on, or give you some confidence to be able to move forward, in a complex and scary system sometimes. And it can be overwhelming, it can be confusing. And so I just hope this is a benefit to you. So first question is, what role does county probation and diversion have in juvenile mental health treatment? So I just want to say that no two cases are exactly alike. There are no cookie cutter cases. And so we want to be mindful of, when we engage the youth and families we have before us, to kind of do what's best for them. And so I think it was Laura that mentioned at the outset of this, the Idaho system is a bifurcated system. So you have the state, and you also have the county that kind of oversees probation. But no matter where you are in the juvenile justice system, in Idaho, we follow what's known as the balanced approach to juvenile justice. The judge definitely talked a little bit about that when she talked about competency and things like that. But what the balanced approach is, there's three parts to the balanced approach to juvenile justice. There's community protection, there's competency development, which we've kind of been talking about, and then accountability. And all of those things should be working together to do what's best, not only for the community, but for the juvenile and the family, because what we want to do is just ensure they have the opportunity to have a great, positive life, being productive citizens. So what role does county probation have? We're going to sit down and take all the information we have, whether it's any type of assessments or recommendations from different counselors, providers, hopefully parents are at the table, and move forward in following these recommendations. We're not, for the most part, mental health professionals or experts. We rely on experts outside of the system sometimes that are in the community, but we rely on that feedback. So is a probation officer responsible to make sure the youth complies with the terms of probation? Yes, that is one of our roles. When a person is put on probation by the court, it's one of our roles to work with this youth and try to connect them with services in the community. But it's also our role to report back to the court if there's compliance issues. And a lot of judges, I know in Fremont County, our judge likes to have review hearings. So it isn't just negative. We also report back compliance and positive and how well a kid and family's doing on their probation. So that is one of our roles. And hopefully, at least in our county, we like to take that positive approach. We are honest, if there's challenges, but we try to focus on the positive and address the hurt, the little bumps, but then we move forward. So, but that is one of our roles. We have to be honest to the court when the court asks us anything and make sure that there is compliance with any type of orders in the probation contract. The next question is, can a probation officer require a youth to receive mental health treatment? Yes, and I would hope that most of the time this isn't a forced issue. We want to work with families and do what's best for the youth we have before us. A lot of times, if there's mental health things going on, the courts might have already required that. So we're just going to enforce a court order. There are terms and conditions of probation that also ask that anyone on probation comply with any assessments and treatments and different things like that. Again, it's not to be punitive, or if we're bored, we're trying our best to rely on evidence-based practices to do what's best for the kids and their families. And that might take a lot of different approaches depending on the issues at hand. So common questions from families. How do I know what my child is supposed to do while they're on probation or in a diversion program? This is a great question, and I think this is a theme that everyone has kind of been touching on, but ask questions. It's okay to ask questions. It's okay to ask the question twice or three times if you really don't understand, or if you need clarification, if you need a little more time with the probation officer. Sometimes we are overwhelmed with everything that's going on. There's a lot of different cases. We have reports that we have to prepare, but it's okay to just, if you're feeling overwhelmed or confused, take a breath, ask us for a little more time with us. We're going to sit down and do our best to either answer your question or find someone that can answer that question. Now, the reality is sometimes it may not be the answer that you want to hear, but I hope it's delivered in a way that's respectful and able to still continue to move forward. But we're going to do our best to answer those questions. So again, ask questions. Questions are okay. Questions are good. Next question is, am I supposed to check in regularly with the probation officer, or is there a way for me to report progress or missteps? Yes, and this should, when you're first come onto depending on the county, but I would say this would be uniform throughout the state, and even throughout different states if they're participating in this. There is a sign-up procedure that should list any type of check-in requirements. Now, check-in might be different depending on your level, your risk level, or your needs. It's fairly common up front to check in more regularly if the kiddo is doing well and moving forward and just connected to services and responding in a positive way, you know, back to that competency that we talked about as part of the balanced approach, then we're going to back out a little bit, and check-ins may be less regular. But, you know, if there's a hiccup or there's something that needs our attention, you should have either your probation officer's contact information when you meet them for the first time, or there should be some sort of office number you can notify probation, you know, after hours. If there is an emergency and during hours, there shouldn't be a problem. They might not be able to answer right away. And I get this sometimes more often than I probably should, but I will get someone that, you know, a couple days later, I've been trying to get a hold of you, but I haven't gotten any type of messages. So I might get a missed call, but they don't leave a message. So I would ask you, you know, we might be in a hearing, we might be in a meeting with another family or a staffing. Please, if you do reach out, you need to talk to us. We might not be able to answer right away, but if you leave a message, we should be following up. Now, if it's a period of time and you're not hearing back, sometimes a probation officer might be out for an illness or different things. You should be able to reach out to that office or their supervisor and just explain your issue and what's happening. So that's what I would say. Now, next question is, what do I do if my child needs to leave the home for short or long-term mental health treatment? Again, talk to your probation officer. You should be having regular contact. They shouldn't be scary or anything like that. You should have a fairly good partnership with them. They should be supportive and listening to you. So just either in your regularly scheduled meetings, or if there's a crisis or something where your child needs to be out of the home for long-term, just let them know. And your probation officer should just be aware and can kind of give you some feedback, or again, answer any questions in that moment that you might have. But just reach out, let them know. These things are regular and they happen, and that's okay. So tips for positive collaboration. I think we've been talking about this a little bit, and it's true. Maintain an open dialogue to understand expectations and get questions answered. We've talked about that. Sometimes the answers may not be what you want to hear, but we're going to be honest with you and again, hopefully respectful, and let you know what those answers are. View the probation officer as a resource, not an adversary or enforcer. And I would like to really highlight that too. Some of my cases, some of my favorite cases to work with is when I can team up with the parent and child to kind of engage them and help them find ways to be successful. It's much greater of a challenge when someone's in my office or one of my staff offices, when they might feel that they can't trust us or they can't work with us. That creates barriers and challenges to long-term success. So it's always more beneficial, I think, for everyone when everyone's working together. We're not against you. We don't want to catch you doing negative things. We really want to help you and your child be successful. And then the next question, if there are unresolved concerns, speak with the probation officer's supervisor. And that's true. Sometimes you just can't have agreement, or sometimes there's issues that come up. You can definitely reach out and find out who an officer's supervisor might be and have the discussion with them. And
so I guess some of the things that parents say,
sure.
Isn't it the probation officer's job to drive my kid to school? If he wants him at school, isn't it his job to get him there? How would you respond to that?
Well, our job is not to be a parent. sometimes the court and our probation contract mandates that they're in school or they go to treatment, but we can't be parents to 70 other kids on the caseload and some of these basic. We might try to work with you to problem solve if you can't get your child to treatment sometimes or school once in a while, but we just don't have that ability. That's not our role. We're not going to take over your role as a parent to make these decisions that you should be doing. We want to support you, but we're not going to take over and do these things. Does that answer your question?
It does. And I think that I just wanted to make sure we were clear that, when we say, probation isn't an enforcer, that means they're also not a parent. So I guess the next question we have is, a lot of parents are unclear on the difference between diversion and probation. So how would you answer that?
That's a great question. And so what we want to do is have the minimal amount of contact necessary in the system as possible. So if someone, let's say, for example, is truant or they're not going to school, that is a different issue than someone that is stabbing someone.
Oh, yes.
A Walmart, that's very significant. We don't want to, if it's just someone making a minor bad decision, like sneaking out of class to go be with their friends and go get a coffee at Starbucks or something else, that's different. We don't want to pull them into the system. So on cases like that, where they don't pose a significant risk to the community, there's probably limited prior history, we're going to divert them if we can, depending on the county. Every county is a little bit different, but do our best to provide them maybe with some services or options to help them make better decisions, to kind of equip them to a better job. Now, if someone poses a risk, then we are going to do those assessments and make recommendations to work with them a little bit more intensively. So diversion is designed to take those low risk, maybe status offenses or one-time first bad decisions and keep them from going into coming into the system, if we can do that by keeping the community safe, but also helping the kid and family move forward with more appropriate decisions.
I think that helps. Thank you very much, Darren.
Yeah.
So now we're going to talk a little bit about the Idaho Department of Juvenile Corrections. We're going to talk to James. We've heard a little bit. People will call this DJC or IDJC. And these are the correction centers that are run by the state in Idaho. So this is also from the handbook. The Idaho Department of Juvenile Corrections is not a system of punishment. The focus is teaching youth the skills they need to have healthy, safe, and productive adolescent lives. I think that's what every parent wants for their kid: healthy, safe, and productive. So James, go ahead.
Well, thank you again, and thank you for taking time out of your day to be here, because I know with competing demands of life, giving up time to learn about this system is much appreciated by those of us that participate in this system. Before I get into the questions, I just want to kind of give the picture of what IDJC's goal and philosophy is with regard to our mission to support youth and families. And the first part of that, the priority is youth safety and staff safety while they're in our care. And then we utilize what we call the 5 pillars to help develop youth into those productive citizens and be able to transition back in the community. We focus on cognitive behavioral therapy, education, counseling, skill building, and family engagement, all part of that balanced approach that Darren mentioned earlier, with the competency development, the accountability, and community protection. And part of that is making sure kids are safe while they're in our care. Our goal is to work effectively with families in helping youth. So work with a number of individuals within the state, primarily a juvenile service coordinator and a rehabilitation specialist, sometimes also known as group leaders and JSCs if your youth is in IDJC custody. What role does the Idaho Department of Juvenile Corrections have in juvenile mental health treatment? And it's a mixture from a number of assessments to what we do while they're in our care. Primary role of the mental health treatment is to create a level of stability that helps increase their success in dealing with other issues that resulted in IDJC commitment. We are not a mental health treatment center. We're there to help resolve the issues that resulted in them not being safe within the community. And so oftentimes the mental health issues or other issues create some instability in being able to address those. And so we want to make sure that they are learning the skills that they need to learn to be effectively transitioned back to the community and reintegrated with their families or whatever the reintegration plan may be. Oftentimes, we do have youth that come into IDJC custody that may return to the community through independent living. They may be of age that home is no longer the placement plan, but that doesn't mean we don't want to work with the families. We want to engage with families and be a part of that system throughout the process. Some of that skill building is mentioned, education, the family engagements, and any other components of program. With all youth, we try to use a trauma-focused approach, and safety, again, is a top priority. There's always a clinician on duty, similar to what Mindy mentioned with detention centers. While they're in state's custody, there's always a clinician that is on call or can be accessed for those emergency type situations within the facility for self-injurious behaviors or crisis or suicidal behaviors. And then IDJC has a community role in helping protect the community. We also want to release youth when they're at their best, when their risk has been lowered and when they are on a path towards success. So constantly looking ahead towards transition and reintegration to the community with the family and the community. And the JSC or Juvenile Service Coordinator is the primary contact for that. Second question was, do youth in custody of IDJC receive mental health assessment? And I would say, yes, they receive a number of mental health assessments. When they're first, if in the court hearing, they're committed to the Department of Juvenile Corrections, they'll have early communication with a juvenile service coordinator who will also be in contact with the family to do a family engagement questionnaire to learn more about the family, to learn more about their social history. They'll go through, usually in the first 21 days, an observation and assessment where we use best practice assessments to determine risks and need of juveniles and the best placement for them. Some of those assessments are the YLS-CMI, the MACI, the GAIN or SASI, sometimes a psychosexual evaluation, a JESNIS inventory, education testing, IQ testing, also vocational testing to identify what their interests may be in the future. So they do receive a number of assessments, and sometimes they'll receive additional assessments as part of their placement if issues arise that early on assessment may not have caught or addressed. They may get a neuropsychological assessment. When they get close to release, if they're going to be returning to the family and at an age where they can continue to participate in mental health services in the community, often we'll have them work with a community provider to get a CANS or other assessments as needed prior to return to the community, or a follow-up GAIN assessments if there's substance abuse issues, follow-up psychosexual evaluation if there's sexual misconduct issues. What if there's already a court-ordered treatment plan in place? So IDJC doesn't ignore anything that's happened into the community. We actually want to build off it, anything that we know that has worked in the past or what hasn't worked in the past. And so the community treatment plan that they may have had will be reviewed. All of the things that the services that they've received will be reviewed as part of that observation and assessment. And while they're in custody, they'll get a service implementation plan. And parts of that may be included in that service implementation plan. But the primary, as we discussed, as I discussed earlier, is to target those risks and needs that resulted in them being committed to the Department of Juvenile Corrections. And oftentimes there's nothing in a silo. So to address this one issue, you also have to mitigate issues related to past trauma, to mental health issues, to developmental disabilities, if there may be some. So all of those things are looked at in that individualized treatment plan or service implementation plan. Looking at the next questions for common questions from families. What steps happen before my child is sent to a juvenile correction center? And there are many steps, as we've discussed earlier today. It shouldn't be a surprise, even if it's a very egregious offense, a serious felony offense where it's quite certain that the individual should be in IDJC custody. That there's still a long process to get to that. In very, very few situations, they may be waived to adult court, and that process would also be a lengthy process. But if they've followed the path that is typical for the majority of youth that end up in IDJC custody, all of the things we've talked about today have been tried. They've probably participated in diversion. They've gone to a number of court hearings. They've had screenings possibly for 2511A and Rule 16, and if sanctions and diversion efforts, probation, possibly more hearings and detention time, increased services at the community level. Oftentimes that can be residential treatment for substance abuse or other issues that have been tried. So the goal is to keep them as close to their home or in home while also maintaining that safety in the community. And if all of those things have not successfully been able to do that, then there'll be the Rule 19 screenings, sometimes more than one Rule 19 screening, and then another court hearing to determine if IDJC custody is the most appropriate option. Am I responsible for paying for mental health care while my child is in the custody of IDJC? Not for the mental health care, no. Similar to what Mindy talked about, none of the services in IDJC or a pay per service type situation. However, when youth are in IDJC custody, parents may be responsible for something similar to what would be child support. That's the easiest description. It's called parent reimbursement, and typically that is $150 per month per parent. But all of that is based on orders from the court and working through those situations, and not everyone pays that amount. And so other services, we may use your primary health insurance for some services, but all medications and all of those things are covered if they're in a state facility by IDJC. If they're in a residential reintegration type program, they may qualify for Medicaid when they're back out into the community.
So James, we have numerous questions, and as we're looking for the tips of positive collaboration, surprisingly enough, it's to keep communicating, just like at every other stage. So I wanted to make sure we had a chance, because some of these fall into your lap, and some of them actually everyone should see if they should listen to. One of them is if a child has a mental health issue and has been involved in the juvenile justice system, what coordination is there as the child transitions to being an adult if there's still criminal activity? And I think this is something that as we have our kiddos get closer to 18, we worry about, You know, we may be already in a system. We may not be in a correction center, but we may have a probation officer. We may be in and out of court with our kid. What happens as they're nearing that adulthood stage and we are still actively having criminal activity? Is there a plan? Is there something we do? Or do we just wait?
I would say if there's still all of those things going and they're not an adult yet, if the crime was committed prior to them turning 18 and the court and probation recommend that the best opportunity for them is still to be served through the juvenile justice system, then kids can be committed to IDJC after their 18th birthday if the crimes were committed prior to that. Now, if they're over 18 and they commit a felony behavior or convicted of a felony, then they fall outside of the scope of the juvenile justice system. But if they're on probation, and let's say they're 18 on probation, there are still a number of avenues. And inside of custody, even after 19, if a custody review board determines that they should be retained in custody, all of those services and probation can continue up to the 21st birthday.
Okay, that's good to know. So
the goal isn't to get them to the adult system. The goal is to help them be successful so that they don't enter the adult system.
Okay. So one of the questions that we get from a lot of parents is what happens when a child has serious mental health concerns and reports their parents to child protection or puts in a claim that, you know, they were hurting them or neglecting them, abusing them, when in fact what they were doing is getting them mental health care. And this happens, actually, a lot of families tell us that this happens. I tried to get my kid help and they said I was, you know, abusing them. I made them go to psychiatric treatment. It was abuse. And these families end up with reports. And, you know, is the court aware of that? I mean, they can't be the first family that you've ever seen where the kid said, no, mom did this to me, dad did this to me. And this is really you know, it's really a parent trying to get them help. So what do we do? And what do we tell those parents? Because that's something we get quite a bit.
Well, if they're in IDJC custody and there's a report of abuse of any kind, it's our obligation to report that abuse to health and welfare or law enforcement and have them follow up to determine if there was abuse, if there's a safety issue in the home. And that's outside of IDJC's scope, other than once all of the information comes back, the impact that has on transition and reintegration planning. That same situation with probation or detention or to the courts may look much different than that. But I would imagine a safety assessment would likely take place in most of those situations, but I'll stand for comments from many of the other panel members.
Well, I think, and this is something that Judge McGregor, I have a question for you, and that is public defenders work for the youth, but that doesn't always mean that the youth is telling their public defender the full story. So what do we do when we have parents who have some really important information that would impact this, and what the child's desire isn't necessarily healthy or good for them? And as the parent, they know that, but that public defender doesn't work for them. How do they have that voice heard in this process? And you're on mute, so.
There we go. So I guess, first of all, I'd have to say that lawyers have an ethical obligation that guides their behavior and involvement with their clients. And so I can't get too far into that rabbit hole, so to speak. And they will, yes, they represent the child, so they have to abide by their ethical obligations there. Parents need to speak about what they know that would affect the case or the court's decision making when possible and when asked. So I would just encourage parents to speak about things that you're talking about, because yeah, a defense attorney's obligation is to their client, and that isn't always necessarily lined up with the same as the child, the parent and the child are often not seen on the same page.
So, and I know we're about out of time, but the last follow-up to that question is, if competency has been determined in one county, does that hold true if the kid has an offense in multiple counties? They live near a county line and one thing was done in one county and one thing was done in another. Does that competency determination carry between counties, or is it specific to the court that it happened?
No, in my experience, if there's been a competency evaluation in one county, it would be accepted in another county.
Okay.
I would have no reason to question that unless it was done by a person who wasn't certified or authorized to do those evaluations.
So I think because of the bifurcated system, I think frequently parents aren't sure, if it was done here, does it count here or not? And
it should. I mean, I don't want to speak, maybe there's some reason or something like an unapproved evaluator, but in most circumstances, if they're approved, they should be able to transfer from jurisdiction to jurisdiction throughout the state.
Well, and so as we finish up, I just wanted to say thank you to all of our presenters today. We've had some pretty good conversation. The thing that I think that the director of the Department of Juvenile Corrections wanted us to know is that there really isn't any magic thing that happens in the juvenile justice system for mental health that isn't already in our community. And if you go to the website, when we post these slides, you will see a list of resources that we have at the end. And that does include up here that handbook that we have been referencing. And a special thank you again to all of the local county and state agencies that have helped us put this presentation together. We hope that it has helped, and we hope that that it answers some questions for families. So thank you so much for all that you have been here for. We really appreciate all of your time, both the panelists and those who have been watching. Thank you very much and have a wonderful day. Bye-bye.
Thank you.
Thank you.